Hey, I'm Nancy Cavey, National ERISA and Individual Disability Attorney. Welcome to Winning Isn't Easy. Before we get started, I've got to give you a legal disclaimer. This podcast is not legal advice. The Florida Bar Association says I have to say this. Now I've said it, but nothing will ever prevent me from giving you an easy to understand overview of the disability insurance world, the games that carriers play, and what you need to know to get the disability benefits you deserve. Today, I'm going to talk about the carrier's right to offsets, their right to offset VA benefits, Social Security retirement benefits, and rollover distributions of IRAs. So why am I going to talk about this? Because these are the kinds of common questions I get all the time from people who are on disability benefits questioning why there is an offset or a reduction and what, if anything, they can do about it. So we're going to start off by answering the question, can a disability carrier reduce long-term disability benefits by VA benefits that the policyholder was getting before the disability insurance claim was filed? I'm going to talk about how the court approved a disability carrier's reduction of a quadriplegic's benefits by a rollover distribution of an IRA. I'm going to talk about how a carrier like Aetna might be able to deduct Social Security retirement benefits from your ERISA long-term disability benefits. And lastly, I'm going to talk about a federal judge who called out a disabled policyholder who refused to give the disability insurance plan information to calculate the offset of settlement monies. Got it? Well, let's take a quick break before we get into this episode. Welcome back to Winning Isn't Easy. Can an Aetna, like any other disability carrier, deduct Social Security retirement benefits from your ERISA long-term disability benefits? Now, many disability insurance policies or plans allow for the deduction of Social Security retirement benefits from long-term disability benefits the policyholder is entitled to receive. But as always, the devil is in the details. You need to get a copy of your policy or plan to determine whether Social Security retirement offsets are allowed. There isn't any uniform disability policy or plan, so each is different. And of course, the answer is going to be different based on your unique situation. But let me give you an example. In the case of Smith versus Aetna, the policy provided that monthly benefits payable under the policy were to be the lesser of the scheduled monthly LTD benefits and the maximum monthly benefits minus all other income, but not less than the minimum monthly benefit. Now, that's as clear as mud and clearly probably written by a lawyer. The policy defined other income to include disability, retirement, or unemployment benefits required or provided for under any law of a government, including benefits under the Social Security Act. So this was the provision that they relied on in deducting from Smith's long-term disability benefits any Social Security retirement he received. Now, Smith said, whoa. There's an exception to the rule, and that is that the Social Security retirement benefits that the insured received before the date they became disabled under the plan shouldn't reduce their monthly benefits. In other words, if Smith began receiving his retirement benefits before he became disabled under the plan, Aetna couldn't deduct the benefits. On the other hand, if Smith began receiving the Social Security retirement benefits after the date he became disabled under the plan, then he said, look, Aetna, you've got the right to deduct those Social Security benefits from my disability benefits. So the question becomes, well, first off, did Smith get his Social Security retirement benefits before or after he became disabled? He argued that he should be deemed to be disabled in February of 2016 because that was the day he became eligible to get his monthly long-term disability benefits. Now, the court said, well, wait a second, isn't the issue the date you became disabled and not the date you became eligible to receive the long-term disability benefits? Because in this case, they weren't the same dates. Smith had begun collecting his short-term disability benefits in August of 2015, and he was eligible to collect his long-term disability benefits some 26 weeks later, or February of 2016. He began receiving his Social Security retirement in December of 2015. Under the terms of the policy, the period of disability begins On the first day, you are disabled as a direct result of any significant change in your physical or mental condition while you're insured under the plan. So in Smith's case, the date of disability was August of 2015. That was the date he stopped working and the date he began receiving short-term disability benefits. He didn't become eligible for LTD benefits until he had satisfied the 26-week elimination period. So the plain language of this plan provided that the date the person became disabled was before the date Smith was eligible to receive his long-term disability benefits. And he was disabled under the terms of the policy in August of 2015, and his eligibility for the LTD benefits didn't negate the fact that he collected those Social Security retirement benefits in December of 2015. So the court, in applying the plain language of this, in my view, very confusing offset provision, said, hey, Aetna is entitled to deduct the Social Security retirement benefits from his long-term disability benefits. Got it? Sort of clear as mud, isn't it? The key, as always, is the language in the policy or the plan and applying it to your unique factual circumstances. In the next segment, I'm going to talk about how a federal judge called out a policyholder who refused to give the disability insurance plan information to calculate the offset for settlement monies. If I'm not going to give you the information, you can't take the offset argument. Got it? Let's take a quick break before we head into this section.